Hello and welcome to our lecture on Supreme Court processes. We continue with this short discussion of processes from Chapter 2, Supreme Court processes from Chapter 2, and if you will look at Figure 1-2 in your text, you will see the very complex process the court uses to decide what cases it's going to decide. I want to take a few minutes and talk about and go over a few elements of this complex process. So we see the numbers there of cases that come to the court each year. This does not mean the court decides all these cases that get entered on its docket. Close to 8,000 cases get appealed to the Supreme Court every turn, and each one of them is assigned a docket number. But that doesn't mean that the court decides all of them. The Supreme Court has discretion. And that's an important term, to decide whether to decide just about all the cases that come to it. The Supreme Court has the discretion to decide whether to decide just about all the cases that come to it. So of the around 8,000 cases that parties appeal to the Supreme Court from a lower court, of these cases that get placed on its docket, the court decides only about 1%. Furthermore, about 6,000 of those cases that come to the court come to it as habeas corpus petitions. These are usually petitions from prisoners, people already incarcerated, and they usually file what's called in forma pauperis, which simply means in the form of a pauper, someone who has no monetary resources, and so the court makes special provision for them. Of those 6,000 cases, only 0.06% of those cases get decided by the Supreme Court. So what happens to the other 99% of the cases that are appealed to the Supreme Court? Well, the decision of the court below remains the final decision for those cases. As you can see, that makes courts below the Supreme Court very, very powerful. All right, so there are three avenues of appeal to the Supreme Court of the United States. Three ways of getting your case before the Supreme Court of the United States. First, you can ask for a writ of appeal, but you can only ask for a writ of appeal if you are bringing a case to the court under the Civil Rights Act or the Voting Rights Act. For these kinds of cases, the court does not have discretion. It has to decide them. Congress has said so. But only a very few cases come to the Supreme Court on a writ of appeal. The second way you can bring your case before the Supreme Court is by certification. But these are not requests from the parties to the lawsuit asking the court to review the decision below. No, these come from the courts below. The judges in those cases have a question as to law and the legal concepts of the application of law to a particular case, and they ask the Supreme Court to clarify those legal concepts for them. The final way, and the most important one for our purposes, is to request a petition for a writ of certiorari. A writ of certiorari is a discretionary writ. The vast majority of cases coming to the Supreme Court, including all of those 6,000 cases that are filed by prisoners in forma pauperis, are discretionary. The court does not have to hand out a writ of certiorari just because the parties ask. Also note a couple things here. First, certiorari is a Latin term meaning to be informed, or you might interpret it as send the record to us. This simply means that the Supreme Court is asking for the record of the court below so it can review it. You should also note that the parties may ask for a writ of certiorari, but if the Supreme Court issues it, it doesn't go to the parties. It goes to the lower court, and that court has to send all of its records to of the trial and appeal to the Supreme Court for review. Okay, so routes of appeal refer to ways cases move from lower courts to the Supreme Court. Now, the Supreme Court, you'll notice in Figure 2.2 that what we see there is a display of how cases move from federal and state trial courts through courts of appeal, and then finally to the Supreme Court. Now, the Supreme Court has the power of national judicial supremacy. This means that it can review the decisions of state Supreme Courts, but only when those decisions involve an interpretation of the U.S. Constitution, a decision that some act of Congress is or is not constitutional, or some decision about a federally protected right or interest. The Supreme Court will not review state court decisions, state Supreme Court decisions about its own constitution and its own law. Clerks and justices consider a number of factors when making the decision about whether to grant certiorari. These include whether the case has certain characteristics. And if a case has some of these characteristics, we call that case cert-worthy. In other words, it's worthy of receiving a grant of a writ of certiorari. It's one of the cases the court is likely to grant review. And here are some cert-worthy characteristics that the court itself has outlined in its own Rule Number 10. If there is a conflict among lower courts, often among circuit courts or state Supreme Courts, on an important matter. So if two similar cases are decided by different circuit courts, the Supreme Court will try to resolve the conflict. Secondly, if the case involves an important legal question that hasn't been decided, the Supreme Court is likely to grant review. Thirdly, a lower court, if in a case a lower court has decided a case in a way that conflicts with established precedent, then the Supreme Court will likely take the case, and of course they have the opportunity then to either overturn the precedent or overturn the decision of the lower court. And also, there is a person called the Solicitor General, and this individual is the government's top litigator. This person is so important that they have their own office in the Supreme Court building, and some people refer to them as the 10th Justice. And if the Solicitor General supports review, then the Supreme Court is likely to take that person's thoughts into consideration. Current Supreme Court Justice Elena Kagan was Solicitor General of the United States when she was nominated by President Obama. Notice that seeking justice and correcting errors leading to a miscarriage of justice is not really on the list. Why is that? Well, the Supreme Court does not view itself as an error correction court. Its primary goal is to seek consistency in law, and it is not there to resolve wrongs primarily. Its job is to maintain consistency in law, to be the steward of the Constitution and our federal system, and it is not going to overturn convictions because an injustice has been done or something like that. I think that's very interesting. A lot of people don't really think of the Supreme Court in that way. So, how does the Supreme Court decide to decide a case? Well, after a case is placed on the court's docket, a legal clerk will write up a memo about the case after reviewing the entire record. That memo, about 6 pages long or so, will include a specific recommendation from the clerk to the justices about whether to grant or deny review. Now, the role of the law clerk is absolutely crucial. Justices read those memos, and they also read the recommendation of the clerk. That recommendation is the most important factor in getting your case heard by the Supreme Court. Another thing the justices take into consideration is whether any amicus curiae have submitted briefs. Amicus curiae is a Latin term meaning friend of the court. It refers to briefs filed in support of or against granting certiorari by people or organizations who are not party to the suit. However, they have an interest in the outcome of the case. The court considers whether amicus curiae have filed briefs, and the clerks usually reference these in the memo. You might want to note that amicus curiae can file briefs at 2 different stages. They can file it when the court is thinking about granting certiorari, And then after the court has granted certiorari for those select few cases, amicus curiae can then file what are called briefs on the merits, urging the Supreme Court to decide the case in one way or another. So, once the clerks have written up memos, the justices place some of the cases, between 20 and 30% of those 8,000 cases that were appealed to the Supreme Court, on something called the discuss list. This is a list of cases that the justices will discuss and consider granting review. So if your case doesn't make it onto the list, you're probably already done. Supreme Court won't even directly consider granting certiorari. Nobody thought it was important enough to put on the discuss list, and so your appeal is over. After the discuss list has been formulated, the justices will meet in conference throughout the term to consider cases on the discuss list. And if 4 justices vote to grant certiorari, then the court grants it. This is called the rule of 4. There are 9 justices on the Supreme Court, and all you need is 4 to get a grant of certiorari. So you do not even need a majority to get certiorari granted. These conferences in which the justices consider the discuss list, they occur throughout the term. There's a very big one at the beginning of a term called the long conference, but others occur throughout the term, about every 2 weeks. And at these conferences, the court considers cases on the discuss list, but it also votes on how to decide cases that they have already heard in oral argument. These are the cases that are given full treatment by the court. The justices will take an initial vote, and excuse me, we seem to have lost our, here we go. The justices will take an initial vote during the conference, and they will discuss the merits of the case, and then they'll take a final vote and make opinion writing assignments. So the important point here is that at conferences, the justices will consider whether to grant certiorari to some cases, and then they will make the final decision about other cases that they've already granted certiorari and heard oral argument on and read all the briefs on. Note, however, that the votes of justices at this conference often change after the conference. Thus, majorities, outcomes, and opinion writing assignments change all the time. In fact, a vote on a case is never considered decided until the opinions are released to the public. The votes are constantly shifting even after a conference has concluded, and the justices will communicate with that to each other through memos. So that is a brief overview of Supreme Court processes. Read the chapter closely for other important concepts like the role of attorneys, what oral arguments are like, etc. Thanks for listening.